But while we are getting started, I wanted to go over a couple of housekeeping items just to let you guys know what to expect. So first thing is you will notice that we have a Q&A section on our webinar. Feel free to take advantage of that Q&A. That is for you guys as we're going through to ask questions. If there are questions that we can answer on the spot, we will, but we will set aside some time at the end of our webinar to address as many of those questions as we can. So please feel free to take advantage of that. You'll also notice that your cameras are off and your mics are muted. So if you need to communicate anything or ask any questions, please use that Q&A to do that. Second thing, just so everybody knows, this webinar is being recorded and will be made available to you at the conclusion of the webinar. You'll get that via email. You will also get a second email from myself with some resource documents that Greg has made available for us, and he's going to go over those with us during the webinar so you know what to be expecting there. Lastly, that might be it. So with no further ado, I'm going to pass things over to Gerald McMichael. He is our agency owner and president, and he's going to get us started. Thanks, Gerald.
Yeah, thanks, Jen. Well, good afternoon. For those of you that I haven't met yet, it's a pleasure to meet you virtually. My name is Gerald McMichael. I'm the president of McMichael Insurance. We have a great topic lined up for today. Recreational drug use law and how your businesses will be impacted, and maybe already are. McMichael Insurance started nearly 50 years ago as a family-owned agency, and we are still family-owned, extending the same hospitality and family feel to our staff and to our clients. The agency has expanded to provide insurance services nationwide, serving both commercial and personal insurance clients. We are viewed inside the industry as a thought leader and expert in coverage application and interpretation, and as a provider of expert solutions and superior services by the business community. This webinar is sponsored by McMichael Insurance in conjunction with the National Tooling and Machining Association and Excelis IT, a network security and managed technology solution provider. The NTMA is a national organization representing the custom precision manufacturing industry since 1943. They have nearly 1,200 members nationwide, and they support the manufacturing industry through local chapter support, workforce development, advocacy, and discount buying power that they bring to their members. Welcome, NTMA members. Excelis IT provides network security and managed technology solutions nationwide. Of course, being in the insurance industry and a provider of high quality cyber risk insurance, I tell my clients that insurance should be seen as your last line of defense. But more importantly, what everyone needs is a great front line of defense. I've had those panic calls from my clients. Monday morning, first thing, ring, ring. Gerald, the FBI's here. My computer screen's been compromised. I'm staring at a blue screen telling me they've locked down my data and will release the data key to me once I pay them, in this case, $400,000. Yeah, we had insurance in place, but you don't want to go there unless you have no other options. That's where Excelis IT comes into play. Excelis provides that front line of defense to keep the cyber criminals out of your backfield. Let Excelis do the heavy blocking and tackling for your business. So welcome, Excelis clients. I also believe I owe you a little bit of an explanation of my agency's relationship with Greg Meehan. Greg and his firm, GRSM, are in a class of their own. To mention just a few of Greg's achievements, he has achieved super lawyer status. Yep, that's a real thing. He's also received the Lawyer of Distinction Award, as well as designated as a Michigan top lawyer, which is another thing. Yeah, Greg did attend Michigan State University. Ohio State fans, don't hang up yet though, because he did receive his Juris Doctorate degree from Ohio, from the University of Toledo. Greg, I'm glad you threw us Ohio State fans a bone. But here's the best part. Listen up. This is important. As an added benefit to the clients of McMichael Insurance, we make the services of Attorney Meehan and his his services to our clients available at no cost. Yeah, you heard that right. The cost of his services have been totally underwritten and are available at no cost to McMichael Insurance clients. So, maybe thinking now, maybe there's something there I can take advantage of. Let me tell you a few of the services Greg has performed. These are just the ones I know about for clients of McMichael Insurance. Writing and creating an employee handbook from scratch. Consulting on termination procedures for employees who are no longer carrying their weight. Discussing recreational drug use with a Michigan-based client of mine. That's pre-Ohio recreational drug laws. That's why I thought of him when Ohio got hit with recreational drug use laws. He helped establish, on many occasions, employee performance improvement plans. Those are important because that's your steps to terminating an employee with the hopes that they rehabilitate. But if they don't, there's very important steps in that plan to show you've done your diligence to try and rehabilitate that employee. He has rewritten an entire employee handbook to accommodate recreational drug use laws. So I know he's one other thing that's important he's going to get into here. When are you able to run drug testing on specific employees without having them be random? So that's just to name a few things. So I know those rather lengthy. So I'm going to turn it over to Greg. I'm very pleased to present to you Mr. Greg Meehan, attorney at law. Greg, floor is all yours.
Hey, thank you. Welcome, everyone. Just a few kind of comments. I manage the employment and labor practice at Gordon Reese, Scully, and Manzacone, and we are in all 50 states. One of the few, in fact, we're the only law firm that can say that we have offices in all 50 and we practice employment law there. What I want to try to do in the time that I have with you, and it's not a whole heck of a lot, is to go through some of the things that get employers most in trouble as it deals with drug testing, reasonable suspicion, kind of give you an outline of how Ohio law has evolved and how it has at least become one of the few states that has protections for the employer if you are aware of them and you use them. So if we could put the PowerPoint up real quick. And while that is happening, I do want you to know that I have two documents that will be sent your way. One is a termination checklist that I had created about 7 years ago that I have found that if employers, before they make the decision to actually go forward with the termination, they take a look at this document and they go through all of the questions that I ask you to look at. And at the end of that, if you're able to answer those questions, your termination, in my experience, is going to be upheld. And we've had 99% success rate on defending terminations that have followed that checklist. The other good thing about the checklist is that you will then know where you are deficient and where to go back and get the information you need to ensure that your termination will withstand a just cause, at will, or a discrimination claim in these cases. And we're seeing more and more and more of that today, as you well know. We tend to have more of a more difficult employee group that you all have to manage and deal with. And the second checklist is a reasonable suspicion checklist. And again, it can be adapted to meet your specific needs, but it is crucial to have that checklist to go forward with it, specifically in Ohio with recreational marijuana come into play and with regard to what you decide. Now, before we do the first slide, I want to say something, and I'll try to say it 3 times in a row throughout this presentation. What's beautiful about the state of Ohio is that as it relates to cannabis, recreational, and medical marijuana, you are allowed to frame the policy and procedure that you want. And in fact, it is the baseline of the entire process that we're going to talk about. So you will see throughout this presentation how important it is to have your understanding of what you want to do, have that reflected in a policy, and then follow that policy, because Ohio empowers you to do that. This is not like some of the other states like Illinois and others, which basically dictate what you can and cannot do. First slide, please. So when we look at this, it's medical and recreational marijuana, making the right decision from the employer's perspective. I'm going to talk about medical and recreational because the two are simultaneously used and are part of the process. So next one, please. So the federal approach to marijuana, as many of you know, it's a Schedule I drug. You cannot possess it, cannot take it across state lines, cannot have it on your person. Next slide. For the reason being, as a Schedule I narcotic, it's illegal. And in some contents, it constitutes a felony. We've heard for the last 15, 20 years that that's going to change, but it hasn't. So as a result, there's this inherent conflict between state law and those states like Ohio who have approved marijuana under certain circumstances, and the federal law, which says it's a Schedule I violation. The federal law to marijuana, there are no Title VII protections to an employee. There's no ADA protections to the employee. There's no protections in terms of being hired with or without the use of the drug. And there's no hiring and firing protections. In other words, under federal law, as an employer, you are not going to be subjected to being sued using federal law like Title VII, like the ADA, like FMLA, and other types of federal statutes because you've taken discipline action against an employee as a result of either testing positive for marijuana, recreational, or medical, or because of the testing. The fact of the matter is, in the federal law, there is absolutely no protections at all. Next slide. Now, Ohio is a little bit different state law. And as you know, federal law controls, for the most part, certain rights, and many of the discriminatory rights that exist for an employee in the marketplace today come from federal law that have been adopted by state law. So in Ohio, medical marijuana became effective in 2016 by way of a legislative right. It didn't really come into effect or use until 2019, but nevertheless, that started in 2016, and as you all know, recreational marijuana was approved by the voters November of last year, but you still can't buy it yet because Ohio is still going through all of the processes of trying to get licensing and the infrastructure set up. However, employees in recreational are entitled to have on their person in a non-work related environment up to 2.5 ounces. Next one, please. Ohio's medical marijuana control program does not require employers to accommodate employees who use medical marijuana. So I want to kind of focus on that for the moment. What that is saying is that under state law, even with a medical marijuana card, you as an employer do not have to accommodate that employee's use of marijuana at the workplace, despite the fact that they have a medical marijuana card. Now, we'll talk about in a moment that you have to address the underlying issue that gave rise to why they use marijuana medically, but you do not have the obligation under the law to accommodate their need to use. In other words, you can bar it completely from the workplace, from the parking lot, from their person, no distribution, no any of that. You can also bar it if you have and want to have a drug-free workplace. You have to if you work for federal contracts, but for state, you can have a drug-free workplace also that would allow you to exclude even having to hire a person with a medical marijuana card. But again, we go back to how is your handbook set up and what are the policies that you have. Next slide. Employers have discretion with regard to employees' medical marijuana use and can hire, discharge, move, make tenure decisions, or demote employees based upon its use. So if you were to decide that you were not going to prohibit someone from getting a position because they have a medical marijuana card, you still have the discretion to use that status in terms of what you do or do not do with that employee and how you move them along, as long as, again, the status is based upon the marijuana use and where you would permit or not permit. Now, when we go back, and I don't want you to go back on the slide, but when we look at the prior slide, remember, you are entitled to have a drug-free program if you wish. You are entitled to not have to hire anybody who has a medical marijuana card if their use of medical marijuana will occur at work. They can't bring it to work. And if they test with marijuana in their system, you are entitled not to employ them if you so choose to do so. Similarly, if they are already employed and they get tested and you determine that, hey, you've got marijuana in your system, despite the fact of having a medical marijuana card, you have the option as an employer, as stated here, you can discharge, move, make tenure decisions, or demote the employee based upon that. So the power, even with a medical marijuana card, sits with the employer, provided that the policies that you have are drafted in a clear, concise manner. Next one. Employers can maintain a drug-free workplace act. That's the federal law that requires that, and that would require no one test positive for marijuana. And Drug-Free Safety Act, Ohio, that prevents a purpose from use and or testing with marijuana in the system. If you're going to adopt that kind of program, you have to follow through on it completely. You have to ensure that your testing protocols pre-hire will provide for that kind of continued and fair treatment so that everybody is operating under the same process. Now, one kind of side note here, I do understand the workforce that is available out there. I do understand and have heard many employers say to me, hey, Greg, there is no way I cannot try to adopt a policy that involves marijuana, because if I do, I don't have people that will work for me, or I will lose that workplace. And if that happens to be you, understand that there's some things that we'll talk about and how you can control that, protect that, and still keep you in good stead so that you're not looking at thousands of workers' comp claims, injuries, and other types of issues. But right now, I just want you to walk away from it. On medical marijuana, you have the right to control how and what you do with it. And it can be a bar to employment, and it can be a bar or cause of termination if the person is determined to have marijuana in their system, if you operate under a drug-free safety policy in your employment. And again, if it's federal, you have to do it automatically. And there may be certain jobs that just require that also. But we can talk about that individually on a client-by-client basis, because there are some jobs that OSHA deems just to be totally dangerous, and the ability to have a right for a person to have marijuana in their system for other jobs in your employ, but in this particular job, it can be excluded completely. Next one, please. Ohio law expressly states that an employer is not subject to a lawsuit if an employee suffers an adverse employment action, termination, demotion, failure to transfer, failure to give a bonus, based on medical marijuana use, as long as the decision was made based in accordance with company policy and is not discriminatory. So again, we have to go back to this idea that the policies that you create in the beginning are the safety net that you need for the enforcement process. And then secondarily, you have to be consistent and not engage in disparate treatment, where on one hand, one employee is determined to have have marijuana in his or her system and you fire, but then another person that you deem to be so important, so crucial to the understanding and activities in that department that you just give them an EAP program or they go through drug rehabilitation programs, etc. We have to make sure that we follow the policy that we do if we're going to have a drug-free policy, and we have to make sure that our application is not discriminatory to anyone. And if you do that, Ohio law says you can't be sued. And again, this is a rarity, everyone. There are many states that take quite the opposite approach, that if you don't do this right, or in disability law, you have to accommodate them. So here, Ohio, you guys are protected again, but you have to decide where you want to go. Next one, please. What about disability? Neither the ADA, Americans with Disability Act, or Ohio discrimination law requires an employee to accommodate use of medical marijuana with regard to a disability. However, please understand, if you've got a person that comes to you and they have a disability and they wish to go get a medical marijuana card and they wish to use medical marijuana to assist with their disability, and you have a drug-free program in your employment, you can deny them employment if they use marijuana, even though the medical marijuana card is issued. But what you can't do is you can't ignore the underlying medical condition. And that means then you still have to engage with them in the interactive process. And for everyone that knows and thinks about ADA, don't lose the words interactive process. That should always be in every writing that you have with an employee that believes they have a disability. You want to write in, hey, let's you and I get together and engage in the interactive process for me to understand what you need and for you to understand what we need. So in this case, it is perfectly okay for you to say you cannot use marijuana in our employ here. But I still have to talk with you about what your disability is and what I can do to accommodate you for that underlying issue. And there may be other things that will help alleviate the pain, the problems, or the issues that are associated with that disability. Now, each of these cases are going to be dependent upon a case-by-case basis, but I want you to understand that just because they have a disability doesn't mean you have to accommodate medical marijuana use. It means that you can deny them the right to use medical marijuana, but you still have to address the issue on whether or not the underlying reason for use of medical marijuana or anticipated use can be accommodated in other areas. And I want to take a brief break for a moment and think about going on another deviation. Those of you that watch the news a lot are aware that in June of last year, the United States Supreme Court kind of did a nasty in what we call the legal field. After 45 years of looking at the ADA and accommodations in a religious discrimination case, ruled that the idea of whether you have to accommodate or not, that standard was a hardship. And the standard used to be that if it was more than a de minimis hardship, that was enough. So if it cost you more than $5, $10, $100 to accommodate that person's request for an accommodation, that was more than de minimis, and you did not have to grant that accommodation. The court said in June of last year, oh, wait a minute, for 45 years, we all have been misinterpreting what was originally written. We're not changing the law. We're simply saying the law was misinterpreted, and now you have to show a substantial financial hardship when you decide not to grant an accommodation. Now, this applies in all areas of the ADA, in all potential disabilities, not just marijuana disability kind of issue, but religious, feet, body, and everything else. So just keep that back of your mind that the law changed about 7 months ago, where now employers just simply can't say it's a hardship and it cost us too much time to be without that person, so we're going to deny your leave, which is deemed to be a appropriate accommodation under circumstances. Now we have to show a substantial financial or substantial burden to be able to deny that. All right, next slide, please. That's the one we just talked about. So we can move to the next one. Thank you. Workers' comp. Disqualification for benefits under the workers' comp may occur if post-accident tests show marijuana use. So one of the issues is if a person's got a medical marijuana card and they get into an injury, and of course, we'll talk about testing in a moment, why it's important. One of the reasons why you do testing, although many Ohio employers, not many, but some, have decided they're not going to do pre-employment testing. I still think that's dangerous, but nonetheless, they're not doing it for marijuana. You do want to continue to do testing for accidents, injuries at the workplace, because marijuana in the system under Ohio not only is a defense to a workers' comp claim, but you'll see in a moment it's a defense to an unemployment claim also, specifically if you terminate the individual for use or having marijuana in their system. Next slide, please. All right, medical marijuana testing, pre-testing, many considerations. Again, company policy. As I said to you ago, there seems to be a small trend of employers who say, I don't have an employment pool that isn't using marijuana, so I can't not hire someone that has marijuana in their system. What do I do? Well, what we do is we decide whether or not pre-testing is of value to you. If you are the type of company that is not going to prohibit someone from having marijuana in their system, either recreational or medical, then pre-testing for marijuana may be a waste of time for you and a waste of money, primarily because it just doesn't give you any information at all that helps you with regard to the employment of the situation. On the other hand, if you're drug-free, you've got to do pre-testing. And thirdly, if it's a job that they're doing that has special circumstances under OSHA, then you should do pre-testing also, so you can ensure that. The employment market dictates this. And the insurance concerns that I have as to why you still may want to do pre-testing, even when you're allowing people to work who may use marijuana recreationally and or may use marijuana through a medical marijuana card, is you want to ensure that you monitor your employees appropriately, because there is been a large uptick. I don't know what the percentage is, but I believe states like Colorado and others who first started this saw a large uptick of workers' comp claim, personal injury claims on the job, personal injury claims at home, and other types of injuries that affected the workplace, whether it was an ADA or FMLA or other type of similar issue. So whether you're going to pre-test or not depends upon, again, what your philosophy is. Do you want to ban marijuana completely, or do you want to make it such that if it's in their system, that's fine, as long as they don't bring it to the workplace, they don't use it at the workplace, and they aren't arriving at the workplace under the influence, much like alcohol, right? If you want to treat it that way. Next slide. The testing post-accident, this is where it becomes important. Workers' comp requires it in Ohio. It can be very effective in helping defend UIA claims. And by the way, if you do random testing during the workplace and you find someone has marijuana and you are a drug-free workplace, you're terminating them for having marijuana in their system is not, it does not allow them to get a UIA claim. In other words, they're prohibited from collecting unemployment insurance benefits as a result of that. The new OSHA rule is not such a new rule as it is a confusing rule that keeps changing internally. But what OSHA has cautioned employers about post-accident testing is that if you make it as a matter of course that you test and your workers' comp law does not require testing, Ohio's does. So this conversation is more academic for you than anything else. But if Ohio didn't require workers' compensation testing for drugs in an accident, if it didn't require it, the OSHA rule would say you can't test the person who got involved in the accident or who was injured unless you tested everyone else around them who may have been a contributing factor to it. The idea behind OSHA was that they believed that employers were using the testing process of drugs and marijuana and alcohol as an arbitrary way to get rid of employees, as a way to target employees. And they wanted to ensure that unless that accident looked like it was the result of some form of under the influence of drug or alcohol, you better not be testing, because if you do, and alcohol and drugs had nothing to do with it, but that yet they had drugs in their system, not of an amount that would put them under the influence, they were getting fired. And that would be unfair according to OSHA. So in your case, that's more of an academic at a bar, having a glass of wine, shot of tequila kind of discussion for you, because Ohio does require for workers' comp claims that these people get tested, and there are protections by doing that. Next slide, please. Recreational marijuana, as you know, that just came about in November of 2023 to be effective 30 days thereafter. It's not available at this point in time because the licensing issues have not been worked out. There is a law that permits a certain amount of limited plants to be grown individually. You can't sell them, but you can use them for yourself. And it permits the person to have on their person 2.5 ounces. All right. Next one, please. Again, section 3780.35. This is simply kind of a reprint of the medical marijuana statutory scheme. Employers are not required to permit or accommodate an employee's use, possession, or distribution of adult use marijuana. You can refuse to refuse to hire, to discharge them, you can discipline, or take adverse action against an individual who uses recreational marijuana and has it in their system. Again, this means that at the beginning of the employment, and if you do pre-testing and they test positive for marijuana, if they have a medical marijuana card and you have a drug-free work environment, you can refuse to hire them. If they don't have a medical marijuana card and you have a drug-free work environment, you can refuse to hire them. Similarly, during the work, if you have a drug-free work environment and someone is either in an accident or random testing or reasonable suspicion testing and they come back positive, medical card won't save them and the recreational won't save them. You have the ability to take an adverse employment action against them, which is firing them, which will prevent them from getting unemployment benefits and will shield you from any lawsuit, provided that your company policy is clear and provided that you are applying this equally amongst all similarly situated people. Next slide, please. Employers have the following right. This is kind of a quick recitation: not permit use or accommodate, refuse to hire, can discharge or take adverse action, establish a drug policy and testing policy, and discharge for marijuana is deemed to be just cause and may affect UIA claims to the benefit of the employer. So if you wanted kind of a quick snapshot of it, this is what the program, the recreational law that came into effect provides for employers in terms of things you want to do. But again, we have to take a step back and say, well, what is our desire? What is our mission? What is our handbook? What do our policies say? And how do we effectuate that all the way down? Next one, please. So I put together what I call a 7-step plan of action. And by the way, in addition to the 2 handouts, you're going to get a copy of this PowerPoint. The first is design the work environment you wish to have. Everything that you, sorry, there's a typo there. It should say everything you do next is based upon the work environment that you wish to have. So you should take a look at departments, work, injury rates, and all of these different things, and decide what does your company need and what do you want to have in place for the protection not only of yourselves, but fellow employees, the public, and everyone else. But it's up to you in Ohio to create the environment that you want to have. Okay, next step. Review and update testing protocols and policies. You either decide to stop or continue testing pre-employment, or do you want to do random testing? Next slide. In the middle if you want. And do you want to, at that point in time, of course, you have to do post-testing situations. Number 3, update your policies. Whatever it is that you decide you want to do, we need to create those policies for you. And I've done that on a number of different Ohio companies, probably about 30 of them. So if you get to the point where you've decided where you want to go, whether it's allowing marijuana, but not in the sense that they're under the influence, or whether you wish to preclude it completely, we can develop that for you. And it's part of the program. It's not an additional cost or expense that you would pay. Number 4, offer training. One of the most important things is training managers and supervisors on what is reasonable suspicion, conversations with employees, and clear disclosure. So let me take these in parts. The clear disclosure to employees of a company policy to create a proper expectations is so important. When you decide what way you're going on this and how you want this to work, part of creating the policies is then communicating those to the employees in a very clear, articulated way, and then getting them to sign off on the process to ensure that they're not going to say later on, well, I didn't know we could do this. I just had a labor case where the guy claimed that he didn't know that vaping in a highly flammable paint booth somehow was a prohibited policy for the employer. And he didn't know, even though about a month ago, another gentleman was vaping and made himself a baked potato because he caught himself on fire and everyone else. People will say these things as a way to try to put themselves in a position that they didn't violate the policy. So you want clear information. 2, you want to train your managers and supervisors of what does reasonable suspicion look like. It's very amorphous to be able to identify. It's kind of like Justice Potter Stewart once said on the first pornography cases before the U.S. Supreme Court, when he was asked if he could define what pornography was. He finally, in his Supreme Court opinion, wrote, I can't tell you what it is, but I can tell you when I see it, what it is. And similarly here, when you have managers whose job is to ensure that people are not operating under the influence, whether it's under the influence of prescribed drugs that they just took improperly, or whether it's under the influence of illegal drugs, whether it's the influence of alcohol, or whether it's the influence of some kind of chemical that they may have absorbed into their system while they're working, your managers and supervisors need to know what are the keys, what are the signs, what words can be used, what communications should be had, what smells should be looked for, and all these other things. And so one of the documents that I had prepared and you will be getting is an actual reasonable suspicion checklist. Now, I would like to work with you, if you're going to use this process, to adapt that to meet your specific needs. But from a general perspective, given to a manager who's never had any training at all, can take this checklist and can watch an employee and mark off boxes of what they are seeing. And then that will support the argument that I have a reasonable belief that you are under the influence of what I don't know, so we're going to go get a drug test. And that will help us defeat discrimination cases or disparate treatment cases where you say, oh, wait a minute, you're only using this not because I'm under the influence, but because you don't like that I complained about you, because you don't like the fact that I'm black or white or Asian or Indian, or you don't like the fact that I'm male or female, and you're discriminating against me for those reasons. No, you get to look at the sheet and say, no, I could tell by your eye dilation. I could tell by the slur of your speech. I could tell by the smell. I could tell by the fact that there were long moments of not movement. You know, you can go on. So training is the fourth step that a checklist will start, but we can provide a little bit more for you in that regard. Next slide, please.
Yep, and Greg, I'll go ahead and let you know we have just under 20 minutes left, about 17 minutes left. We don't have any questions in the Q&A yet, so if anybody has any questions for Greg, feel free to post those while we're getting to the tail end here.
You got it. Last chance agreements. So for those of you that are not wanting to exclude people that have marijuana in their system and would be more than okay, like alcohol, if they decide to use it on their time and not put the company at risk. And when they come to work, while it still may be in their system, it's not going to be in a situation whereby they are under the influence. One of the ways that you can engage is if you don't want to terminate, you can always engage in what are called last chance agreements. Other agreements we call sometimes are called performance improvement plans. But this is just a step that gives you an idea that it's really up to you in your planning of how you want to deal with violations of your drug policy. Termination is one way, but whatever you do, you want to do it consistently all the way through. And if you're the type that says, well, you know what, I'm not that kind of company, so maybe we'll do an EAP agreement, maybe we'll do a last chance agreement, maybe we'll do a PIP. You get to formulate that. The concept is let's get thinking about how we do it anyway. Next one, please. Continued communications. What you want to do, in my view, is continue to inform the employees of what you expect of them. I will tell you that I have been trying cases for 36 years. I've tried over 150 in this country and 10 in Europe. And I will tell you more than anything else that the biggest problems that employers face are employees who don't have an expectation of what you want from them. They should have. They've been told 50,000 times what that expectation is. But I'm telling you, it's the 50,001 time that you need to do. And so the more you communicate with them what's expected of them, whether it's drugs, whether it's work, whether it's how they communicate, it's whether how they say things, it's whether they engage in inappropriate activity, the more you can communicate with them of what the company expects from them is important. And I want to say one other thing, because I'm assuming I've got HR and or supervisors and managers here. What I have found in a lot of conflict management training I have done is one of the ways to generate a huge amount of good culture in the employment setting is to make sure that the employee understands that what they do on the job impacts you, impacts how you're viewed by your supervisors, by your managers. It impacts to some degree on your compensation and bonuses. It impacts on how you're perceived professionally. So when they're not doing their job, it impacts you to all of these people above you. And most of them don't know, some of them don't care, but I have found that at many times when they are made aware of what they do and what that impact is, it goes a long way. And similarly for you as a manager, supervisor, and HR, if you can communicate a true desire to understand what the impacts for them are, what the difficulties are for them and what they're doing, you create this relationship that allows it to grow and to become important. So communication is crucial. Written communication is more crucial. And if we ever get an opportunity to meet and do a hiring, firing, and discipline seminar, which I hope we will, this will be an opportunity for me to explain how crucial this communication process is to winning cases. Next slide, please.
Yeah, Greg, I have a couple of questions in the Q&A queue.
Yes.
One is, can we get a copy of the 2024 recommended employee handbook and policies?
Yes.
And two, and we'll get those out. You provide them, we'll send them out. Two is, do you foresee where testing will evolve to show recent use similar to alcohol testing, given THC stays in the system for an extended period of time?
Yeah, the two things that are problematic about that. First of all, law enforcement is having all sorts of difficulties when they pull someone over on having any form of test like alcohol to determine that you are under the influence. Now, the law says for alcohol, 0.08 is deemed to be the benchmark that you are under the influence. Now, I differ with that. I've had some cases where skilled workers had 1.8 and didn't appear to be under the influence, but that's a whole different breed of human beings. We don't have that standard yet in marijuana, although there are saliva tests and a lot of testing and science going on right now. And I believe within a year we will have what amount of THC in the body would be the benchmark for that. So what officers do is they base it upon the reasonable suspicion. They base it upon, were you weaving? Did you use your blinker? Are your headlights on or off? What was the smell? All the things that you guys are trying to do with regard into the workplace. So right now, the biggest hammer or success that you have is understanding how reasonable suspicion works, using a checklist, and then going through that process. Hopefully, in the very near future, we will have this number. Second, many of you know there are three ways that marijuana could be tested. And the most accurate one, of course, is the hair sample. And that's not what you usually pay for when you send someone down to the lab because they're under the influence. You can request that hair sample. It's a little bit more expensive in that regard, and it will show greater results. But really, the testing facilities that you go to, even if there's marijuana in the system, until it reaches a certain baseline level, not under the influence baseline level, but just a general baseline level, will not show marijuana. And then when it hits that baseline level, it will show. So you can do the clearly the saliva test that they can do. You can also do the hair. There are other testing that they can do. They're even trying to develop a blood test that is current. But the best thing we have today is your sense of experience, checklists, smell, evaluation, and communication.
Okay, one more question here. In a post-accident work comp test, who requests it? Would the hospital automatically test it if the worker goes to the ER?
Everybody should be requesting it. So the employer, as a matter of fact, should make it a requirement. If the hospital does that, that's great. But some of these accidents won't involve testing. Some of these accidents are a guy driving a high-low in the middle of a plant and runs into the wall and knocks the wall down, but he doesn't necessarily get injured, but there's injury to property. So the test is there's property and personal injury, you would still send that individual potential to get tested. Number one. Number two is you would want them to get tested because there could be a month from now, 3 weeks from now, a workers' comp claim because, oh no, the seatbelt that he had on kind of caused a back spine issue, and now they relate it to the workers' comp. So accidents in Ohio that involve employees, the testing should be mandated by the employer, and it's okay if the hospital does that, but you should be there to ensure that it's being done. Because you never know. I mean, soft tissue injuries sometimes take 6 months to occur. And then it's very easy to figure out going backwards. Well, if the employee is the only one telling you what happened, they're clearly going to attribute 6 months earlier this accident, right? But you have, as an employer, no way to refute that. And then all you're left with is medically, could the accident have caused this injury? And even our medical science, as advanced as it is not able to look at that over time. Now, if it was 2 or 3 years, calcium deposits and all those other things are very helpful. But it's kind of like what we were dealing with in the COVID period. How do you know if the person got COVID at work, got COVID at their friend's house, or got COVID anywhere else? It's virtually difficult to determine. And that's why when you have an incident at work or on the job site, injury or not, that person should get checked out physically, and that person should be drug tested. This way, if there's future workers' comp issue that come down the road, you are now packaged and empowered to move forward. Okay. The seventh step is annual review of policies and handbook. I suggest it's kind of like a trust and a will. Every year, just have your handbook reviewed. We do that. It's not a cost for you. You just send the handbook. We update them. For those of you that had their handbook in 2023 done, you're out of date right now, because many of you may or may not know that in June of last year, the Pregnant Workers Disability Act came into effect federally, that required employers to accommodate pregnant women who wish to continue to work and want to work, to find ways to make that happen. Now, I don't know why we needed that law when we already have the ADA and Title VII that protects that, but nonetheless, that law went into place and is in effect. And not having that in your handbook presents a problem. The second is that many people in their handbooks don't have what is called the NLRB disclosure statement. Many of you that are non-union think, well, why the heck do I care about what the NLRB has to say? I'm not union. And the reason why you care is because, in my personal view, the National Labor Relations Board has been dying on the vine for years. Now, there's a resurgence, but they've been dying on the vine of getting candidates. And what they've been doing recently is, under Section 7 and 8 of the National Labor Relations Act, they have been going after non-union employers who have been terminating or disciplining hourly workers for engagement in their Section 7 and 8 rights. And what are those? Those are rights for an employee to say just about anything they wish to say about their employer, or about the customers of their employer, or about anything else relating to the company, as long as they are communicating that dissatisfaction to another employee, and as long as it is tied to the terms and conditions of their employment. And I'm going to end my presentation with this last example of this. And I had a case, and I won't tell you the state, but it is Ohio. I'm being funny now, where a particular judge had been upset because an employee got on Facebook talking with other friends and made a comment about the size of his genitalia being small, because she felt that he was following her around so much that that he needed to find fault with what she did to make him feel better about his own personal status. And then she went on to explain that this is so difficult to work in this environment, and as a result of that, I don't know what I'm going to do. When this came to light, of course, you can imagine there was a desire to terminate that employee. Unfortunately, and I'll stay away from the obvious joke. Clearly, truth is always a defense to a defamatory claim. But if this employee was engaging what she was in the terms and conditions of her employment, talking about them, and makes a comment that the supervisor did not like, you can't terminate them for the exercise of those rights. Now, you can terminate them for other reasons, such as if they made a threat, or if their comment was one that was defamatory, or if it was harassment, or if it was many of the other prohibited things. But employees, hourly, not salaried or exempt, but employees are protected by the NLRA under Section 7 and 8 of the Act to engage in the terms and conditions of their employment. So there are a lot of things that have changed in the last year in terms of enforcement, that every year we should be looking at the handbooks just to make sure we got the best policies in place. With that said, I don't have anything else other than I can just thank you guys all for spending some time with me and letting me drone on. And I'm not going anywhere, but go ahead.
Yeah, let me just wrap up. We're almost done. I know you've all got a lot going on, but please hang with me just a few more moments as we work through a couple of closing comments. I hope you've enjoyed this webinar and found value you can take back to your businesses. I want to sincerely thank Greg for presenting today. In case you missed my opening comments, please allow me to say it again. The costs of his legal services have been totally underwritten and are available to clients of McMichael Insurance at no cost. I think we need a new motto here, value beyond insurance, because that is really what we're trying to bring to you, not just insurance. You can get that anywhere, but it's the value beyond that insurance that couples us together and makes us a strong partner for your businesses. If you want to talk to Greg about legal help, please feel reach out to him. I want to make sure we're kept in the loop so that we can make sure the insurance coordinates with what he's doing on his end. We will send you his contact information when we send out the webinar recording. One more comment. When you insure with McMichael Insurance, your business can literally save thousands of dollars in legal fees. In addition, when you take advantage of our coordinated legal insurance IT solutions, our insurance carriers will recognize that in their pricing because you are making wise business decisions that save you time, aggravation, and avoid costly lawsuits, which in turn saves the insurance company money. So the next time you think insurance, think McMichael Insurance. You can reach us at 330-626-4972 or by going to mcmichaelinsurance.com and completing a contact form. I might also add that as organizer of this webinar, we do have ongoing efforts to bring this to you on a regular basis. So keep your eyes open in your inbox. Our next event to be announced is coming in March. Our present White House administration has turned the NLRB loose, as Greg has mentioned, on employers, and that creates some real issues for employers. It can get you into a lot of hot water quickly. So we are going to be focusing on that come March. We're going to be talking about how to navigate hiring. We'll be touching on disciplinary issues, as well as the importance of the application process, which many of you may not actually use. So Greg will be walking us through that entire hiring process in March. One question I hear a lot, Greg, and I'd love to see this addressed in that webinar as well, is I regularly get questions about employers. Can I hire this driver? Is the driver eligible to drive? That's a dicey one because that all has to play out in a proper order. And I'm not going to steal Greg's thunder. I'll let him do that. So the question becomes, do I not hire them, or do I offer a conditional employment offer and then fire them? Or do I simply just ignore them? So these are issues that can get you into a lot of trouble. So Greg's gonna walk you through that entire process. I don't want you to miss this because this impacts a lot. If you're on this call because a sponsor, NTMA, Excelis IT, invited you to join this webinar, please say thank you to your sponsor. When we do send this recording out to you, please feel free to pass it along and share it with business owners that you know and collaborate with. So that's all I have. I wish you all a very good rest of the day. Thank you for attending, and God bless.
Thank you. Bye-bye, sir.
Bye now.